No constitutional transformation begins by declaring itself a revolution. It begins with a moment of vulnerability. A judge under threat, a federal official attacked, a state prosecution that seems blind to federal stakes. In such moments, legal restraint can feel abstract, even negligent. The temptation is to act decisively now and sort out the theory later. That instinct is deeply human. It is also how Neagle was born. When the Supreme Court decided Neagle in 1890, it was not trying to expand executive power. It was trying to protect one of its own. A justice had been assaulted. A federal marshal intervened. California charged him with murder. The court faced a choice. Let a federal officer stand trial or recognize an implied executive power to defend federal functions. The decision to protect felt obvious, and it still does. What wasn't obvious, what couldn't have been obvious, was how this moment would quietly shift the grammar of constitutional legitimacy. The doctrine built to shield judicial safety would become the foundation for immunity claims across the modern administrative state. It would travel, first to federal marshals, then to wartime executives, and eventually to immigration officers detaining United States citizens in violation of state law. This is not a story of judicial malice or executive scheming. It is a story of logical accumulation. The Neagle court faced a legal silence. No statute authorized the Attorney General to assign personal protection to a justice. Congress had not foreseen the threat. Yet to the justices, the need was clear. If federal judges could be attacked without consequence, the judiciary itself was at risk. So the court improvised. It filled the silence with inference. The marshal's actions were deemed necessary to preserve the operation of the federal government, and from that necessity, authority was presumed. This was framed not as innovation, but preservation. The Constitution, the court implied, must contain the power to protect itself, even if that power isn't spelled out. The ruling was narrow, almost minimalist. It did not proclaim a general executive police power. It resolved a particular emergency in a way that felt, well, institutionally prudent. And because it felt reasonable, it was left unquestioned. But what was introduced was more than a holding. It was a method. Prior to Neagle, federal power followed a familiar course. The Constitution conferred it, Congress implemented it, the executive executed it, and the judiciary policed the boundaries. Neagle introduced a soft reversal. Sometimes, it suggested, federal power could be inferred from function rather than text. If the federal government needed to act to preserve itself, the power might be presumed, even in the absence of legislation. This shift was not packaged as a theory of executive supremacy. Instead, it was framed as continuity. The language of necessity disguised the method of improvisation. But the pattern had been altered. Once judicial validation could follow action rather than precede it, constitutional time itself began to run backward. The next emergencies arrived quickly. In re Debs, back in 1895, the court actually upheld federal intervention in a railway strike. Not because Congress had specifically authorized it, but, well, because the national economy and the mail system were under threat. Again, the government's ability to function was the justification. Again, the text was secondary. During World War I, President Wilson acted pretty aggressively to mobilize industry even before Congress had fully authorized him to do so. Later on, FDR invoked wartime necessity to justify domestic surveillance and internment, policies that were often ratified after the fact. Each action felt unique, crisis-specific. Each prompted hesitation about formal limitations, and each time courts leaned toward deference. toward preserving flexibility over enforcing structure. No ruling ever announced that necessity now generated power, but the logic repeated and precedent began to drift. Over time, congressional silence, which had once signaled the absence of authority, was reinterpreted as permission by default. Justice Jackson's Youngstown concurrence crystallized the idea. In the zone of twilight, where Congress has neither approved nor forbidden executive action, he suggested that necessity might tip the balance. That idea was meant to limit power, but it legitimized action in precisely the space where limits were missing. Functionally, this meant the president could act first, and courts would later determine whether Congress's silence should be treated as complicity. What began as a rare judicial indulgence had become a constitutional presumption. Nowhere has this presumption grown more consequential than in immigration enforcement. Federal immigration agents routinely operate under broad, open-ended statutory mandates. They detain individuals at courthouses, separate families, and conduct raids in coordination with local police. Often the statutory basis is vague or simply missing. When states challenge these practices, courts do not ask whether Congress specifically authorized each action. They ask whether the federal government was acting to enforce immigration law in general. So, the assumption is clear. Because immigration is a federal domain, and because the executive is acting to preserve federal enforcement, necessity fills the gap. Just as the marshal in Neagle was protecting a justice, ICE agents are said to be protecting the national interest. But unlike Neagle, the targets here are not threats to judges. They are children, families, legal residents, and sometimes citizens. The stakes have changed. The reasoning has not. When necessity substitutes for authority, harm often happens first. Law follows later, if at all. Immigration cases, well, they abound with examples. United States citizens mistakenly deported, detainees held for months without charges, state officials blocked from investigating abuse because federal supremacy was claimed. And because federal action is presumed valid unless clearly forbidden, accountability is slow and uncertain. Officers are shielded by functional immunities, even when acting outside their formal mandates. This is not what Neagle was meant to permit, but it is what its logic allows. Over the past century, courts have increasingly treated interference with federal officers as presumptively unconstitutional. If a state seeks to impose civil penalties or criminal sanctions for unauthorized federal conduct, courts often assume the burden falls on the state to prove the federal officer acted unlawfully. This flips the constitutional presumption. Instead of asking whether power was lawfully granted, courts ask whether power was clearly denied. Instead of insisting on statutory authorization, they rely on functional necessity. And over time, immunity becomes not an exception, but a baseline. Each ruling cites the last. Each case inherits the logic of cumulative indulgence. The trail leads back, again and again, to Neagle. The most profound consequence of this evolution is its opacity. No constitutional convention approved broad officer immunity. No statute expressly authorizes action without constraint. No amendment endorses necessity as a generator of power. Yet the system has shifted. Each generation inherits a set of assumptions it did not choose. What began as judicial protection now, well, justifies expansive enforcement powers. What was framed as emergency logic now, honestly, governs daily administration. This is how constitutions change without amendment. not through dramatic declarations, but through steady reinterpretation, built case by case. This is not an indictment, it is a reckoning. Judges were responding to real threats. Officers were acting in the moment. Courts sought institutional stability. Emergencies distort judgment, especially when the threat is to the government itself. But what Neagle teaches is that logic accumulates. One exception becomes a framework, one indulgence becomes a habit, and soon the foundational rule, that power must come from law, gives way to a new one, that power will be tolerated so long as it feels necessary. Neagle did not announce a new theory of constitutional power, it embedded one. Quietly, incrementally, it substituted necessity for authorization, inference for law, and emergency logic for constitutional design. That substitution was not limited to a single case or context. It reshaped the relationship between the branches, softened the constraints on executive action, and displaced Congress from its constitutional role as the sole originator of federal power. Today, Neagle is no longer a narrow precedent. It is a foundation. It underwrites the doctrine of implied executive powers. It sustains expansive views of federal officer immunity. It justifies enforcement actions unmoored from statute. It functions as an unspoken premise behind countless acts of federal discretion, especially where congressional silence or statutory ambiguity might once have blocked them. This cannot be corrected with better balancing tests or refined judicial standards. The constitutional error lies upstream. It is not about how necessity is weighed. It is about whether necessity belongs in the constitutional calculus at all. The answer is no. The Constitution contains its own logic of power. It grants authority through enumeration, delegates it through legislation, and constrains it through structure. Where necessity appears in that framework, as in the necessary and proper clause or the suspension clause, it is expressly conditioned, tightly bounded, and institutionally assigned. It is never allowed to create power where none exists. Neagle bypassed that logic, and in doing so, it rewrote the role of the judiciary. The court that was meant to police constitutional limits became an instrument for dissolving them, first in emergency, then in routine. Legitimacy was no longer grounded in what the Constitution permits, but in what the judiciary tolerates after the fact. To restore constitutional discipline, that chain must be broken. The proper remedy is not to limit Neagle, it is to overrule it. Overruling Neagle would not destabilize legitimate executive functions. It would restore the rule that all federal power, protective, prosecutorial, administrative, or otherwise, must trace back to an act of Congress or an express constitutional provision. It would reaffirm that the judiciary's role is not to fill in gaps based on necessity, but to enforce the boundaries the Constitution establishes. Emergencies will still occur, government will still act. But if new authority is needed, Congress can provide it, and if the constitutional design is inadequate, the people can amend it. What cannot be allowed is the quiet substitution of urgency for law, or the continued use of Neagle as a backdoor to power that the Constitution does not grant. A constitutional order that permits power to arise from necessity is one that no longer remembers where power is supposed to come from. Neagle must be overruled, not to undo the past, but to reclaim the future.